So first and foremost, I just want to kind of recap the program, how we take attendance, how you're going to receive credit for today's webinar. So again, if you are watching this webinar from somebody else's computer, please be sure to make sure that information ends up in the chat on GoToMeeting. If I don't see your name in the attendee list, I'm going to have no way to know. So if you're watching with somebody else, just have them type in the chat and say, hey, XY is watching with me, and that'll work for me. Now, I mentioned this on last month's webinar, but we are going to do something a little different today as far as receiving credit for the webinar. So throughout the course of this webinar, I'm going to give you a bunch of information. And at the end, what we're going to do is we're going to give everybody a quick 5-question quiz. It's going to have a scenario presented to you, and it's going to have, 5 questions essentially. Most of these questions aren't multiple choice, so we're going to know if you guys are copying answers. So I highly recommend that you guys do these individually, but truthfully, if you're paying attention on today's webinar, you'll have more than enough information to be able to answer all the questions on this quiz. I'm going to circulate that quiz via email as soon as we're done with our webinar, and you'll need to return that to me by the end of the day tomorrow in order to receive credit for this class. So contrary to last month's webinar, you will not receive credit simply by showing up. You'll have to complete this quiz in order to receive credit. And again, this quiz is not overtly difficult. It's just a matter of us, checking to see, are you retaining the information that we're presenting to you, and are you finding it easy to understand and digest? And your leadership staff seems to believe that, yeah, I think this is a very clear and concise webinar. So we just kind of wanted to, remind everybody that that's the plan moving forward. And again, just as always, after 5 credits that you receive for attending these webinars on a monthly basis, you do get an extra half day of PTO. Again, you will need to have your branch manager's approval to take that extra half day, but it is sort of an incentive that we're offering just for attendance. So now that the clerical stuff is out of the way, let's go ahead and get started with our very first topic. We're going to talk about residential versus non-residential. This is one of the more common questions that I received after last month's webinar in regards to defining residential real property, selecting policy premiums and endorsements, and how to tell the difference between the two. Now, this topic is highly confusing and is probably one of our top 3 losses across the region from people not selecting the correct type of endorsements based on the type of policy or the type of property that we're insuring. So we're going to go ahead and get started at the very beginning, which is defining residential real property. Now, residential real property is actually defined for us through procedural rule number 1, section U. And is defined as any property which has improvements thereon designed principally for the occupancy of 1 to 4 families and is in a platted subdivision of record. And if it's not in a platted subdivision of record, is consisted of less than 5 acres. So again, we want to make sure there is an improvement on the property for people to live in. It's in a platted subdivision, or it's 5 acres or less. However, there is a second way to identify residential real property, and that includes property that could be more than 5 acres, but less than 200 acres. And in order to qualify under this particular clause, there has to be, again, an improvement for 1 to 4 families, and they have to have the ag exemption on the property. So if the very first test isn't met, say the property is 10 acres, then you might still be able to define a property as residential real property, assuming, again, it's less than 200 acres, there's a 1 to 4 family residence designed specifically for occupancy, and the property is used for agricultural purposes. Now, if you guys get a contract in your office and you're noticing it's maybe 10 acres, but your tax cert's not showing an agricultural exemption, but your record owners are insistent this is residential real property, you can get with the underwriting department. We might be able to make an exception. And this is important because being able to identify residential real property is the first step in knowing exactly what type of policy and premiums that we're going to be issuing, both for the owner's policy and for a loan policy. So again, this is probably one of the more important things that we need to be able to identify. And truthfully, we should be able to identify this very quickly when we're looking at a set of facts on a file. So to make that a little easier, I've got this checklist that I'm going to circulate for everybody after the webinar is over. And generally, if you were to go down this checklist, it'll tell you exactly how to identify whether your property or whether your contract contains residential real property. Now, in the future, this is probably the sort of questionnaire that you should probably have memorized. You should be able to go through this flow chart in your head. But for those of you who are either new to the title insurance industry or maybe haven't been in escrow that long, this is a really great thing to start to learn to memorize. Because again, defining residential real property is truthfully one of the more important abilities when it comes to opening a file and starting a file and knowing how to insure a particular property. So now that we've learned how to define residential real property, the next issue is selecting the correct type of policy. Now, this is definitely something we've talked about before. It's something I hinted on yesterday at our open order training, but we're going to go into specific detail about it. So selecting the correct type of policy in regards to the owner's policy is what we're talking about here, is defined by procedural rule number 38. Procedural rule number 38 says that a company shall only issue a residential owner's policy on a property that is both residential real property and the insured is a natural person. So we'll get to it on our next slide as far as a two-pronged test, but those two conditions must be satisfied in order for you to issue what's called a T1R. And that's what the formal word is for a residential owner's policy. However, if there are immediately contemplated improvements, if they're going to start construction on a house very quickly, we can still issue a T1R. Now, this is important because, again, if you have a contract that's vacant land, that doesn't necessarily qualify as residential real property, but we're still able to issue a residential owner's policy, provided that, again, immediately contemplated improvements are considered on the property. So that doesn't mean that somebody can buy a lot and say, yeah, I'm going to build on the property, but I need probably another 5 to 10 years to save the money. That's not immediately contemplated improvements. That's wishful thinking at best. So we need to have an actual plan. Again, most of the time, a safe rule is, are they going to start construction in less than 6 months? If they are, I would consider that an immediately contemplated improvement. Now, if you are issuing a T1R under the immediately contemplated improvement clause, you're going to want to make sure that P8 language ends up on your commitment and policy, and that's your pending disbursements clause. If you have a question about P8 language, or you see in your unit that you have a lot of builder contracts, or you have a lot of construction contracts and aren't really sure about P8 language, get with me individually after the webinar. It's definitely a little more specific, and I would say the vast majority of us here at Capital don't close construction loans or construction deals at all. So again, if you have any questions about that, I recommend to just approach me or Stephanie or your escrow officer after the webinar, and we'll be able to clear it up for you. So again, when we're talking about issuing a T1R, there is a quick two-prong test, and this is the one that everybody should probably remember. There's two questions you have to ask yourself when you're trying to identify whether or not you're issuing a residential or a non-residential owner's policy. First question is your buyer or borrower a natural person? Do they walk on two legs? Again, LLCs don't have two legs. They are companies. They're not people. So if they're not, an actual natural person, then we wouldn't be able to issue, again, a T1R. Second question is the property residential real property? Or is construction for new home imminent? So again, immediately contemplated improvements. You need to ask both these questions, and if both the answers to these questions are yes, then you can issue a T1R or a residential owner's policy. But if both of the answers to these questions are not yes, you must issue a non-residential owner's policy. So real life example time. You have a residential contract. It's on a 1 to 4 family tract form. It comes in the buyer's an LLC. Yes, there's a house on the property. Yes, it qualifies as residential real property, but my buyer is not a natural person. They're an entity. So I have to issue a T1. I cannot issue a T1R. Now, endorsements are, again, another very highly erroneous issue for us across both Austin, San Antonio, Houston, and Dallas. Most of the time, it's staff having trouble selecting endorsements between, do I issue the T19 at the residential or the non-residential rate? Do I issue the survey amendment deletion at the residential or the non-residential rate? It's a good question, and it is highly confusing, but I'm going to make it very easy for everybody to understand. There's a simple rule that you can follow when you need to select endorsements for both loan policies and owner policies. So first of all, loan policy endorsements are selected based on the type of property. So not by the type of policy that we're issuing, but the type of property that we're insuring. So in our example before, where we had an LLC as the buyer, but it was residential real property, a T19 on a loan policy would be issued at the residential rate, not the non-residential rate. However, the owner's policy endorsements are selected based on the type of policy that you're issuing. So again, in our previous example, we're issuing a T1, not a T1R. So our survey amendment deletion needs to be based on a non-residential rate. This is highly confusing, but if you follow these two simple clauses, it's going to remove a lot of the confusion between selecting loan policy endorsements and owner's policy endorsements on your closing disclosures and on your commitments and anything that revolves around this information. Now, this information is current. It has been confirmed by our policy department manager. So if this is news to you or you haven't been operating like this and don't think this is correct, come talk to me after the webinar. We can talk about that. But I know that most people, you know, have probably kind of stuck to the, if I'm issuing a T1, I'm just going to issue all the endorsements based on the non-res because I'd rather over-collect than under-collect. Well, yeah, that is maybe a safe policy, but really we should be issuing the policies in a correct way. So again, loan policy endorsements are based on property type, and owner's policy endorsements are based on the type of policy you're issuing. Now, I know I went through kind of a lot of information pretty quickly there, but this is something we've touched on before. So if you have any questions about any of the information we covered just now, feel free to type it in the chat. I'm going to get to the questions at the end of the webinar, and I'll put them on a Word document so everybody can see them. But again, we're going to go over just 2 quick pieces of information. Defining residential real property is done by a 2-pronged test, and selecting the correct type of endorsements for loan policies based on your property. Owner's policy is based on your policy. I know I sound redundant, but believe me, if you have a grasp on this information, you are light years ahead of most of the industry. These are very common mistakes, not unique to capital title. And it's probably one of the more confusing, initially confusing topics to go over when you're new to the industry. So, next thing we're going to be talking about today is the notary public. And this is something in the title insurance industry that we're really never trained on. We're kind of just given a notary application and they say, fill this out and sign it, we'll get you a notary stamp and you can do closings for me. Well, in reality, having a notary commission opens you up to personal liability. We want to be able to define what notary publics are, what notary responsibilities are, some of the ID requirements, so what's an acceptable form of identification for notary purposes and what's not, and quick ways to identify fraudulent forms of identification, because we've seen this across our area recently, where people try and pass off fraudulent driver's licenses, fraudulent passports. So it's good to know some of the quick ways to identify a fraudulent form of ID. So the first thing we're going to do is define what a notary public is. And your notary public is really a public servant or an officer of the state. And a notary public is, in the true sense of the word, a public servant. Each notary public takes an official oath of office to faithfully perform the duties of the office. And a notary public is actually required to post a $10,000 bond with the Secretary of State. So again, you are serving the public. Again, appointment is done by the Secretary of State. You're assigned an identifying number. So if you have a notary stamp in front of you, if you notice, you probably have an ID number. That's required under the state of Texas. You have to have an ID number. Your term under the notary is good for 4 years. So from the day that you qualify as a notary public, you can act as a notary public for 4 years as long as your commission is in good standing. Your jurisdiction as a notary public is statewide. So you could notarize any document in the state of Texas as long as you are witnessing the signature or the execution of a document in the actual geographic boundaries of the state of Texas. Now, there are very few, very select circumstances where maybe you're a bordering state like Texarkana, maybe that city, you might be able to get away with notarizing in another state, but for our purposes in title insurance, we're going to assume that we're not allowed to notarize anything on behalf of the title company unless it's actually located in Texas. So you can't send a document to somebody in Oregon and say, just sign this and I'll notarize it when I get the scan back. I know that's tempting to do because it's easier, but under your notary commission, you're not allowed to do that. Notaries are bonded individuals. So that's not something that most people are aware of. But again, like I said before, you have to post a bond for $10,000 when you're commissioned. Now, most of the time at a title company, you have management that will take care of the bonding for you. Some of you might have noticed that when you get your notary commission back, there's a weird company that you don't really recognize the name of under the bond. That's normal. You have to be bonded as a notary public. It's just something that we take care of on the back end. Now, your notary bond is, again, for $10,000 and is supposed to ensure that the person injured or damaged can recover at least $10,000 in damages. But this truthfully does not protect the notary public from personal liability for the full extent of damages caused by a breach of official duty. So what that means in English is if you act fraudulently or you act negligently, you can be held not only civilly liable for that, but criminally liable for that as well. So I know it seems like that notarizing a document is not a big deal, and that's because, you know, as the title insurance industry as a whole, it kind of seems like not as important as just closing the deal. But know that if you're doing something not kosher, right? So in our example before, we're sending a document up to Oregon, having them sign it, and we stamp it back. That's fraudulent, because as a notary, you're signing saying that I witnessed this signature take place in this state, in this county, on this date. And in reality, you didn't. So if somebody would find out about that and that document was to get, I don't know, involved in some sort of lawsuit or subpoenaed in some way, you can actually lose your commission for this. And I've seen this happen personally. So again, be very careful when you're notarizing documents. Definitely make sure that you're aware that, again, just because you're bonded, that does not mean that you are all of a sudden free and clear from personal liability due to negligence or fraud. And I know that sounds pretty scary, but it should, because it's, again, this is your notary commission on the line. Say you're an escrow officer and you get caught on a subpoena and they revoke your notary commission. Well, good luck closing transactions if you can't notarize a document. So again, think about these sort of things moving forward. Moving on to what a notary seal looks like. Most of us are aware of this, but I did want to kind of get everybody in the loop with what exactly a notary seal has to contain. So notary seals must contain the actual verbiage, Notary Public State of Texas. They have to contain a 5-point star, not 4, not 6, 5 points. You need to have the full notary name and identification number and the commission expiration date. Now, most of our notary seals look like this image here. They're rectangular, but some of you have probably noticed there are other notaries who have circular seals, who have embossed seals. It's fine. It doesn't matter what shape they're in, as long as they contain all this information that's easily legible. It does qualify as a notary seal. Now, what am I required to keep as a notary? This is definitely one of the more common questions that is asked all the time, because there's been some changes in legislation in the past 5 to 10 years in regards to notary books and what I need to keep. Do I need to record information? So we're going to go over exactly as it stands today what you are required to keep as a notary public. Number 1 is a record book, and this is according to Texas Government Code 406.014. That record book needs to contain a bunch of information. For every time that you notarize a document, or you notarize a set of signatures, you need to have the date of each instrument notarized and the date of the notarization. Now, generally speaking, this will be the same date, but not always. You need to have the name of the signer, grantor, or maker. So whoever you're notarizing for, you need to make sure you record their name. You need to have the alleged address of the signer, grantor, or maker. And the word alleged here is really the key word, because they're not asking you to verify that the address is actually correct. You as a notary public are able to rely off the statements and information they provided for you. So if they provide you a driver's license with an address, you're able to use that as their address, because that's the address that they are alleging that they live at. And the last one is you need to have the form of identification used to identify the signer. Now, as a notary public in a title insurance industry, we always want to make sure we have some sort of federal or state ID. As a notary public, you can actually notarize documents if the signer is personally known to you, but I will tell you our underwriters are not cool with that. We want to make sure that we at least have a copy of the driver's license. On top of that, if it's a normal finance transaction, your lender's probably going to have a Patriot Act form for you to sign or fill out, which is going to require you to at least get a copy of some form of identification. So personally known usually isn't enough for us in the title industry, but no, as a notary, that actually is a way to identify somebody. As a notary, you're also required to keep a current mailing address with the Secretary of State. So if you have your notary commission and you work in our Lakeway office and you move to our Austin Mopac office and your primary business address is changed, you are personally responsible for updating the Secretary of State if your address on file changes. It's a pretty easy process, and if you need to update your address, you could always approach me or Stephanie or Don Neal. I mean, people at the corporate can help with this. It's generally a pretty easy process. We just need to fill out a change of address form. You can find that on the Secretary of State's website. And I believe there is a nominal fee to update your mailing address as well. Now, as far as notary books are concerned, there used to be in the Texas code, government code, it used to say that it needed to be a well-bound book, quote unquote, but that has kind of been taken away. So as long as you have an actual book that records this information, you're good to go. Whether that be you have one piece of paper that you print out for every time you notarize something and you fill that out and you 3-hole punch it and keep it in a binder, that's a book. If you have maybe one of the older notary books that we used to use before, that works as well. But I will warn you, and we'll get on to the next slide here, if you do not comply with keeping a record book, you can actually lose your notary commission if you were to be subpoenaed on a deal that you notarized. And we'll get to that in a second. But continuing what we're required to keep as a notary, when we're talking about the notary book, the first piece of information most people ask is, well, what I'm supposed to just record the entire driver's license number or passport number? That seems like kind of a breach of privacy. What if somebody else sees that information? Well, you would happen to be right. According to Texas Administrative Code, Section 87.40, this actually prohibits a notary from recording the entire ID number used to identify the maker or signer. So you don't want to be writing down the entire driver's license number or passport number. You really don't want to be recording that information in your notary book. It's acceptable for us to record really just the last 4 digits of the ID in the notary book. And again, that's because your book is considered public record, and we will get to that in a second. As far as how long I need to keep this notary book, that's also a good question. Texas Government Code 87.44 defines that for us, actually, and says that you must keep this record book in a secure place for at least 3 years after the signing takes place. And know that this book, like I said, is considered public record. So if you were to be subpoenaed, you would be expected as a notary public to be able to produce records for every single time that you've notarized a signature or set of signatures. A secure place isn't really defined, which is why I have that in quotations. Generally, probably don't leave it on your desk at the end of the day. Don't leave it somewhere it could be easily lost. Again, we want to make sure we know where this is at all times, just in case. And again, you can lose your commission for not complying with this requirement. So if you get subpoenaed to court and they say, we need a copy of your notary book, we need to check the information, you say, well, I didn't know I needed to have it. Well, I didn't know is not going to hold up in court. And that's really one of the issues and why we're talking about this, because in title insurance, most of us are not trained on how to be a notary. But if you're going to go into court in a subpoena and tell them, well, I didn't know I needed to keep a book, well, I didn't know I needed to record an ID number, they're going to say, well, that is your personal responsibility to make sure that you are complying with notary regulations. So again, be extra careful when you're notarizing documents from now on. I know that there are a lot of us out there, whether or not we want to admit it, that are not keeping a notary book. But moving forward, you really need to be keeping a notary book. So if you need help either ordering a book or setting up some sort of system for recording this information, approach me. You can ask Stephanie as well. We're happy to help you get into the right direction and making sure that we are operating within the regulations as set forth by the Secretary of State. Now, notarizing a document might seem pretty easy, and for most of us, it kind of seems like we can do that sort of thing in our sleep. But in reality, when you're completing an acknowledgement as a notary, you are doing a lot more information than you're probably consciously aware of. So this checklist here is everything that you need to check as a notary public when you're notarizing a document. Make sure that there's a proper county and state. A lot of the times this is an issue. Your lender has a doc prep firm up in Dallas, you're closing in Bexar County or Travis County, the county says Collin or Tarrant, and we need to strike through and correct that. It needs to be the proper county and state. Again, wherever you are physically acknowledging the signature is where the county and state need to be. A couple other pieces of information that are commonly incorrect, making sure that there's a date of the acknowledgement, and it cannot be prior to the date of the instrument, right? So if you have a warranty deed that's dated March 15th, and they're asking you to notarize that for them today, you can't do it. You can't sign that before the date of the document. And we'll get to what do we do if we notice a document is an error here in a little bit. So the next question that generally ties into notarizing documents is, what is an acceptable form of identification? That's definitely a common issue for us, but there's a really easy process to follow when being able to determine whether or not something actually is an acceptable form of ID. First, you need to have a current ID card issued by the federal government or any United States state government. That ID card must contain a photograph and a signature by the affiant. However, with respect to instruments affecting residential real property, as we defined before, a foreign passport issued by foreign country will suffice. So if they don't have a federal government ID card, or they don't have a state ID card that does contain a photograph and signature, we can accept a passport by a foreign country. Now, I will say, as far as we're on the topic of acceptable forms of ID, here in South Texas, one of the more common things that we're going to see is a matricula. And that comes from Mexico, but that is not an acceptable form of ID. It is not issued by a United States government. It is not issued by the federal government. It does not contain a signature on it. It just has a photograph. So again, we need to make sure that we have both of these pieces of information. And this is why if you're trying to be, proactive instead of reactive about this sort of thing, you really should be informing your clients before they come to closing. Please be sure that you bring with you an acceptable form of photo ID. And you can tell them exactly what that needs to be. because it's very difficult to have that conversation with somebody when they had to either drive or fly up from Mexico and all they have on them is a matricula telling you, and then you have to tell them, I'm sorry, I can't accept it as an acceptable form of ID and I can't notarize your documents. That just kind of lands you in some hot water. So again, be proactive rather than reactive about a lot of this information. And again, in your acknowledgement, you want to note that you were supplied evidence through photo ID, and you need to be specific in your acknowledgments which form of ID that is. So just don't put ID, put TXDL, or put United States passport, or Idaho driver's license, something. Don't just put photo ID. You need to put what type of photo ID is in the acknowledgement itself. So say we get to the closing table and nobody has an adequate form of identity. So they don't have a driver's license, they don't have a passport, they just have a matricula. What do I do? Now, generally speaking, first and foremost, we should be, again, proactive in letting them know that we're going to need this ahead of time. But if you're in crunch time, there are a couple options you have available to you. You could locate a notary who personally knows them. Again, we know that as a notary, you can act as a form of ID through personal knowledge. So if you have a notary who knows them personally, who is disinterested from the transaction, then they could potentially notarize a document for them without an adequate form of identification. Now, I will say you need to have underwriter approval if you're going to do something like this, but know that it is an option available to you if nobody's able to provide an acceptable form of photo ID. Now, the most common question that we get regarding interested and disinterested notaries is, can a realtor be a notary? And the answer is absolutely not. A realtor is not disinterested from the transaction. So if a buyer's agent were to tell you, hey, my client's in the Valley, but I'm going to drive down there and I'll get them all notarized. I'll bring them back to you. That way we don't incur a mobile notary charge. Is that cool with you? Well, the answer is always going to be no. They are interested transactions, and you are not able to act as a notary public if you are in any way interested as a result of the signature. Now, again, if you can't find an adequate form of identity, witness affidavits, that's also a possible solution. But again, witness affidavits, and I have 3 stars here at the end of this, require underwriter approval. So if you, at the closing table, you can't locate an adequate form of identity, you can't just assume that a witness affidavit will work, or you can't just assume that a notary who personally knows your maker will work. You need to have underwriter approval on these sort of things. And again, just as a final reminder, we want to make sure that we are notifying our buyers or sellers of ID requirements in advance of closing. Most people put this with a confirmation of their closing time via email, or maybe a copy of the Alta statement or the seller's statement, and just say, hey, just a reminder, please be sure to bring with you a copy of your driver's license, a passport. But again, don't get caught with your pants down here at the closing table. You want to be proactive about this. It doesn't make you guys look good as escrow teams if you get to the table and they just then find out that matriculars don't work. Now, something that is relatively new that we're seeing a lot is fraudulent identification. I can say personally, I have seen it on at least 3 or 4 deals in the last couple of months, both in Austin, San Antonio, all across the state, really. So I wanted to give you some easy ways to identify fraudulent identification. And it might seem like this is not a realistic thing, right? Who would honestly be gutsy enough to give us a fake ID? Well, I think that question kind of answers itself. When you're dealing with hundreds of thousands, and in some instances, millions of dollars, why not try? I mean, if the people can get to the point where they close the transaction and we wire funds into their account, they can disappear and we'll probably never see that money again. So we need to be sure that we know of some common ways that identification is fraudulently produced and fraudulently presented to you. So there's 2 easy ways that I'm going to tell you right now to be able to identify that. Number 1 is your DD number. So on your driver's license, on the very front of it, I want y'all to, if you have it readily available on you, pull out your driver's license and take a look at it. Your DD number is on the very bottom of your driver's license number. In Texas, that is a 20-digit number. We have seen the DD number be less or more digits than 20. That is one way you can tell that an ID is fraudulent. Some people are lazy or maybe don't know that the DD number is only 20 digits, but we have seen this at Capital Title before, where people will have produced fraudulent ID with a DD number less than 20 digits. That's an easy way to tell, but there's actually an even easier way to tell. On the back of your driver's license, again, if we're pulling out our driver's licenses here, look at the back. On the left side, the word directive does not have an I dotted. The very first I in the word directive, so this I right here, does not have a dot on legitimate forms of ID. So fraudulent IDs will have a dotted I, but legitimate IDs will not. It's kind of a quirk, but it's intentional by DPS and by the Texas state government. So that's a great, easy way to tell. If you're on your way walking to the copier to make a copy of an ID or a driver's license, flip it over and see if there's a dot on the first I in directive. If there is, it's fraudulent. You need to give it back to them and tell them they need to furnish you with a different form of identification. Third, name misspellings. I think we all know how difficult it is to initially get a driver's license. Your Texas Department of Safety and Texas Department of Motor Vehicles is not going to intentionally misspell your name on your driver's license. They need actual documentation saying that your name is legally correct. So if they're telling you that, oh yeah, my name is misspelled on my driver's license, that's red flag number one. It's almost never going to be misspelled. And we want to make sure that we're able to identify that. And again, if you ever see anything that doesn't look right, maybe the driver's license just feels fake or looks fake, ask questions. There is nothing wrong with asking questions. And this is really the only way to determine whether or not a form of ID that's presented to you is acceptable or not. So, going to go into some common notary questions here. Number one, can I notarize a document for my spouse or my spouse's business or relatives? The answer is generally not. If you are interested or you will stand to in any way benefit from the transaction, whether that be financially or any way whatsoever, you are unable to notarize a document. So if maybe your husband is buying a piece of investment property and it's going to be never really homestead, or there's some way that you're going to not have interest in this property. This is all hypothetical. It doesn't really happen. You can't notarize for your spouse because, again, you're interested, right? Because we live in Texas, we live in a community property state. So again, it's just better to be safe than sorry. Don't put yourself in that position, because if that document were to be called into question, whether that be through a lawsuit or some other method of claim, and they see that you notarized the document and they are able to prove that you're financially benefited, you can lose your notary commission. And that makes it incredibly difficult to perform as either an escrow officer or an escrow assistant. Second most common question I get, can I alter or change a document that I notarize? Generally, you can only alter the acknowledgement, not the original instrument. So if you have a warranty deed that your lender has prepared and they send it to you and you notice that the spelling is wrong on page 1 of the grantee's name, as a notary public, you cannot correct that. You need to go back to your lender to redraw those documents if you notice an error. In the title insurance industry, this is more commonly a situation that we're in. So again, we're not trying to strike through information on forms at closing, only the acknowledgement. So in our example from earlier, we were talking about maybe a doc prep firm in Dallas, in Tarrant County. If they're sending you a bunch of documents for signing and they all say Tarrant County in the acknowledgement, sure, you could strike through those, you could correct those. But if their name is misspelled on all the documents, no, as a notary public, you cannot strike through those documents and correct them. Only the acknowledgement. So that's generally everything I wanted to touch on today about notary publics, as well as residential versus non-residential property, how to identify residential real property, how to select policy premiums and endorsements. I kind of flew through that today, so our webinar's only lasted 35 minutes so far. But what I'm going to do is kind of just wrap up what we've talked about altogether. I want everybody to be able to understand in their head how to identify residential real property. So if you're still confused on that, feel free to ask a question in chat. You can email me afterwards. But here in our webinars, there is no such thing as a stupid question. So ask away. I want you all to be comfortable being able to not only identify, but explain to somebody if they have a question about how do you know whether you're selecting a residential or a non-residential policy for owner's policy, and how do you know if you're selecting the appropriate type of endorsements. Believe me, having that baseline of knowledge puts you light years ahead of our competitors, and at Capital Title, that's what we're aiming to do. We talked about notary requirements and acceptable forms of identification. Again, if there's one thing you take away from this, know that as a notary public, the way that you act as a notary public, you are held personally liable and responsible for any actions taken as a notary public. And that means you can also be held civilly and criminally liable for actions taken while acting as a notary public. So be extra careful, making sure that you have, number one, forms of identification that are acceptable. Make sure that you start keeping a notary book if you're not doing so already. That's a requirement. And again, if you have any questions on that or you need help ordering that information, reach out to me, reach out to Stephanie. We're happy to help you. And like I said, we have a simple 5-question quiz that I'm going to be circulating to everybody here in the chat after we wrap up the webinar. You have until the end of day tomorrow to complete this. It's only 5 questions. They're not all multiple choice, and 2 of them do require written answers. So I encourage you guys to do this on your own because truthfully, everybody on this webinar needs to know this information front and back. But if you are having trouble understanding it or having trouble understanding the question, you can approach me, maybe approach your escrow officer. You know, we want to share knowledge here. We don't want to make anybody feel less or belittled for not knowing the answer to something immediately. That's what these webinars are really for, so that everybody can grow and learn and say that they are better off having this knowledge in their brain than they were before. Okay, so I'm going to go over a couple questions in the chat here. Okay, so first question, could you please go over a mobile home as residential versus non-residential property? That's a great question. Now, if you have a property with a mobile home that is designated for, again, 1 to 4 family occupancy and is in either a platted subdivision or on 5 acres or less, or satisfies the requirement from 5 to 200 acres and uses ag, we can consider that residential real property. Now, mobile homes are a little more difficult because sometimes your mobile home can be designated as personal property. So in order to designate a mobile home as real property, or as residential real property at least, we need to convert the mobile home from personal to real property. That's done via a statement of location. And if you have a mobile home file and are having trouble understanding that, let me know. I have fixed quite a few of them recently. They're highly confusing, but in reality, they're pretty easy to do. So no, in order for a mobile home to be considered residential real property, you need to convert the property from personal property to real property, at which point it will be considered residential real property. But at the point before that, you cannot consider that property residential real property. Now, this is more common for mobile homes that were built before about 2010. I believe that's the year where TDHCA started to really get their stuff together in regards to converting property. So most of the mobile homes built prior to 2010, you're going to see probably are listed as personal property still. And once they're converted to real property, you don't have to mess with them anymore because they will be considered real property until somebody elects to convert them back to personal property, which very few people are trying to do. Okay, we're going to talk about, so we're going to go back to our diagram as far as how to tell what is residential real property. So we'll go over this really quick. I'm going to just go through this question right here. Number 1, is there an existing 1 to 4 family dwelling? That's question number 1. There has to be that. And if there's not, we'll go to question 2. If there are construction contracts. Again, we talked about this. Immediately contemplated improvements need to be there in order for this to be considered, again, a 1 to 4 family dwelling. And if there's not, the property is considered non-residential, at which point you need to issue a T1. But if this is satisfied, we'll go and ask ourselves, is the property in a platted subdivision? Well, if it is, then it's residential, but it's not. That doesn't necessarily mean it's not residential. It could be, considering the property contains 5 acres or less. But even then, it can still be considered residential real property as long as it's less than 200 acres and used for agricultural production and is owned by individuals and not a company. These are much less common in our main metroplex areas. So most of the city in San Antonio, most of Austin, this is not as common to see properties that qualify as residential real property that are more than 5 acres but less than 200. However, in the hill countries, you're going to see this sometimes. And just because you maybe work in central San Antonio does not necessarily mean that you won't eventually get a deal on your desk with 100 acres with an ag on it, with a family living on there with a house, in which case we can consider that residential real property. Again, I'm going to circulate this checklist here after our webinar is over. It is helpful information. So if you are still struggling to be able to identify residential real property immediately, just print this out, maybe tape it to your cubicle or hang it up on a wall in your office. It is just a nice checklist to have available to you. Okay, here's a good question. What is our responsibility as a notary to determine the capability of the person signing, i.e. mental awareness, intoxicated, etc.? So I had something written down about this actually, but truthfully, your job as a notary is to say, this person signed before me on this date in this location, and I know this person is who they say they are because they provided an adequate form of identity to me, right? So that's all we're really affirming as a notary public. We're not really concerned with the capability of signing. That's really more of maybe a power of attorney question, maybe some sort of legal question in regards to giving interest in property or giving the ability to sign. But as a notary public, all we are really affirming is this person is proven before me with a form of identification. They signed this document on this date in this location. That's all we care about as notary publics. Now, if they're using a power of attorney or something like that, that's where you stop putting your notary hat on and you put your escrow officer hat on, and you can go down the road to determine whether or not, again, are they in a sound state of mind? Can they actually approve or ratify the power of attorney if they're not in a mental aware or a mentally sharp state of mind? But again, as a notary, we're not as concerned with that. Next question. If a mobile home is already real property, does an SOL have to be sent in order to change ownership? The answer is kind of yes. So you need to have a statement of ownership form done, not an SOL. And then you can do an SOL, but on the SOL itself, it has a box whether or not you're going to change it from residential to personal, or I'm sorry, from real to personal property. In this instance, since it's already real property, we don't really need to do that. But we still want to update TDHCA with ownership records. So if you have a mobile home, definitely get one done. Don't wait. It's definitely better to be proactive about this sort of thing. But if your mobile home is already designated as real property, there's no converting that needs to take place. We don't need to worry about paying personal property taxes and converting two tax accounts into one with the appraisal district. We really just need to worry about updating TDHCA with the ownership change, which you can do with an SOL. Next question is, what would be a possible reason to make mobile home from residential real property to personal again? Good question. So residential real property means that the mobile home is affixed to the land. It is in one single location on the land, and it will always be there. It has to be part of the land to be considered residential real property. So if somebody were maybe to be moving and wanted to move the mobile home from one location to another, that might be a reason that you would convert it from real to personal. Most people aren't going to do that because they're not really that proactive about updating their records. But according to TDHCA, you need to make sure that you do that. So a lot of the times when you have mobile homes, you might find that the statement of ownership and location on TDHCA site says that the mobile home's in one location, but you know based off the survey it's in another. Well, that means it's been moved, and you're going to need to do another statement of ownership and location. It's not as common, I'll say. It's very uncommon for them to convert from real to personal back again. Most people, when it's converted to real property, they just kind of leave the mobile home there until it falls apart. And if they're going to need to have a new one, they just put a new one in altogether. So caught up on questions for now in the chat. If you have any more, feel free to ask. I am going to give us a couple minutes to see if anybody can think of any more. It does kind of seem like that we have a lot of questions about mobile homes, and that's definitely not surprising. They're highly confusing for people that don't do them consistently. So maybe in next month or the month after, we'll talk about mobile homes and how to close mobile homes and how to look out for some of the curative issues that come along with those. This is good information. Again, if you are all seeing that there's one or two topics that you're really struggling on, I highly recommend that you reach out to us, myself and Stephanie and Tom or anybody else. Let us know, because that's the sort of information that we want. We want to be able to provide you things that are valuable to you. Like this information that we've talked about today. Notary information is valuable to people because nobody ever gets trained on how to be a notary. Next question. Can an agent sign an affidavit knowing someone in place of an ID for notary purposes? The answer to that question is no, they cannot. Again, we need to make sure that your real estate agent doesn't sign for anybody. They're not a disinterested party to the transaction. And as a notary public, that's how you need to operate. Real estate agents are not disinterested parties to the transaction. So again, if some agent asks you if they can notarize the documents to save on a mobile notary charge, you tell them, unfortunately not. You should know as a notary public, You are not able to take an acknowledgement of somebody if you are interested or benefit from the actual execution of the document in any way. And in this case, a realtor would benefit from the execution of the documents because after that happens, their seller gets paid and then they get paid. So again, be very careful. It's something that not all title companies will have this opinion, but here at Capital Title and according to the Secretary of State, that's the way it needs to be. I'm just going to give this a couple more minutes. So while I'm waiting to see if any more questions pop up, again, while everybody's here, I just want to actually thank everybody for attending today. It's incredibly exciting that we have 40 people on a webinar plus at 10 o'clock in the morning on a Wednesday. I think that's really exciting. And I think it's awesome that everybody's really excited about taking this information and growing as an escrow professional. And that's truthfully what we're trying to do with these webinars. We don't want to sit here and just lecture you on boring information. We're taking information that's relevant and pertinent to you based on what we're seeing in settlement services, based on some of the things that people have brought up to Stephanie and brought up to me, things that we feel that everybody could benefit from. So again, if there's any information that you are confused about or aren't comfortable doing, like mobile homes, let me know. I'm happy to maybe work that into a webinar here in the next couple months because we always want this information to be relevant. And I know that we did say that a lot of these weren't going to be lecture-based, and I promise I'm doing my best to not lecture you guys every single month we do these. But on the first couple of webinars, we had some information that we really didn't need to have a guest speaker for. We were able to just kind of convey to you through me and through a couple people that looked at this presentation and approved the information on it. So again, if there's something you want to see, or maybe there's something that you feel, we as an area through San Antonio, Austin, and parts of the Valley can benefit from, let us know. We're happy to include it. All right, I'm not seeing any more questions, so here's what we're going to do. If you haven't already, if you have somebody watching this webinar with you and they are not logged in as an attendee to the webinar, please be sure that you put their name in the chat right now. If you email me later and say, oh yeah, this person attended, I'm probably going to doubt that, so be sure to put their name in the chat right now. Again, we're using an honor system here. I understand that there's something that is incredibly incentivizing for people, an extra half day of PTO for just attending these webinars. But the reason we're doing this is not just to give you extra time off. We want you guys to absorb and to learn this information. So again, if you are watching from somebody else's computer, be sure that they type that into the chat before you guys leave. I'm going to leave the webinar open for probably another 10 minutes or so. If there's any more questions, let me know. I'm happy to answer them. Otherwise, again, I appreciate everybody being here, and we will see you next month. And do remember that if you have people in your office that were unable to attend the morning session, we do have an afternoon session today at 2 o'clock. The topic will be exactly the same. The presentation will be virtually the same as well. So if they missed it, no big deal. That's why we have 2 sessions every month. So if we haven't seen them then, we hope to see them on the afternoon session.